Number 4, City of Kennesaw versus Amber Sinclair. Amber Sinclair. Okay. Prosecutors requested a warrant. Warrant shall issue for failure to appear today, and any witnesses and officers subpoenaed today may be excused.
Just walked in. I don't know if it's a case.
Okay.
Officer Burns.
Yep. Burns.
Good.
You can be excused. Your party has not shown up. Mr. Orton. Is this gentleman on the calendar?
I'm sorry.
Yeah, there he is. He's on the calendar for arraignment today. All right, City of Kennesaw versus Colin Orton. Commissioner, you'll come up to the podium. Good morning, how are you?
Good.
Mr. Orton, you have a citation for underage possession of alcohol, and it appears you have filed a petition to enter into the diversion program.
Yes, sir.
The diversion program is an opportunity that's not available for everyone. It's an opportunity that you would have having a clean record and having no diversions in your criminal history. Then if you complete the requirements of this program, then this will not show as a conviction on your record. So there's a great benefit to you in successfully completing this program. Have you reviewed the requirements of the diversion program?
Yes, sir.
Okay, and do you believe you can complete those in the time allotted?
Yes, sir.
As I mentioned earlier, there is a time frame involved in this, and it is a 6-month period beginning from today. So you have 6 months from today's date to complete these. That sounds like a long time. I urge you not to let not to wait till the last minute, because it will sneak up on you.
Mhm.
I do want to go over with you what you'll be doing. You have to pay a non-refundable diversion fee of $305. You'll have to complete 24 hours of community service, complete an alcohol and drug evaluation, and follow any further directives for treatment and counseling from that. Provide 2 letters of recommendation from non-family members. And it's important that those recommendations, that the folks who write those recommendations know why they're writing them. If I get letters that say, I recommend Mr. Orton for any position in my organization, which I get all the time, I know that they don't know why they're writing the letter. So it's important that they understand that. And that's because part of the diversion program is taking responsibility for your actions and accountability for your actions. Are you in school or employed?
Yes, I'm both.
Both. Okay. Where are you in school?
Kennesaw State,
And what year are you in?
sophomore year.
And what are you studying?
Marketing.
And what's your GPA?
I'm not sure right now, but
What kind of grades did you get last semester?
not the best. I was working full time and I wasn't very good at time tasking. So, but I got an A in my summer class this year. So
Okay. And so you're taking that more seriously now,
Yes.
Focusing on school moving forward,
yes, sir.
and you're starting it here in the fall?
Yes.
Okay, very well. You'll also need to write a statement admitting guilt and be subject to random alcohol and drug screens. In this case, the first of which will be today. And you will also need to complete a 500-word essay that not only details the events that led to this incident, but how this has impacted or changed your life as well.
Mhm.
Yes, sir, Mr. Bentley. Sorry. No, you're fine.
It's just Mr. Carlton before we come to first home.
Okay, we'll address that in just a minute then. I'll go ahead and go. We'll call that in just a second. All right, so Mr. Orton, then I think we're down to one thing I need to ask you. If you please raise your right hand. Do you swear or affirm the testimony you shall give in the matter that's pending before this court shall be the truth, whole truth, and nothing but the truth?
Yes, sir.
Are you going to pass an alcohol and drug screen today?
Yes.
Okay. As long as you do pass that drug screen today, then you'll be able to move forward with this program. If you do not pass that drug screen today, then we'll need to see you again this morning and have a rather difficult discussion. So as long as you pass the drug screen, you won't need to see me again today. You can meet with your diversion coordinator and they'll help you get these things charted out to get this done. Okay. So I wish you good luck. If you'll have a seat in the courtroom, they'll call you back in a moment for your screen. And let's see here. Would y'all mind grabbing Mr. Bentley, please? Oh, he missed me. All right. I understand that there was a motion from Mr. Crawford to be argued. Okay, Mr. Crawford, if you'll come on up to the podium. All right, tell me what's going on.
Okay, I believe I'm here for the noise nuisances, which one, I want to go ahead and say, nothing I do first with Jesus accountable is to be a nuisance. I've been an entertainer for the last 20 years teaching kids. I do networking on the computer with this same music. I even, if I had all my stuff with me,
Sir,
go ahead. Yeah, go ahead.
what you're telling me would be testimony in your case, and we haven't actually started the case
Oh, I
yet.
thought that's what we were doing right there. Sorry.
No.
Okay,
it's
okay, cool.
No, the solicitor said that you had a request you wanted to ask me about.
Oh,
your
yeah,
case.
yes. Well, like I said, of course, I would have even come with a nicer shirt or something like that. If I had known today was trial day, I thought today was pleading to make this trial date for this. And I thought this was supposed to be on the 24th. So I've come completely unprepared. So I literally just need mercy to be able to either reset or just have mercy to get rid of it, because I obviously don't have anything. I don't even have my cell phone with me.
What do you need?
I would need your help either way, no matter what I have, no matter what I have to say. So it's all going to come down to what you rule over me and plus what anybody has to say. So I just need your help.
What, and I understand that. You're saying that there's some documents that you need or something you need from your home?
If it would do anything, I have pictures, I have documents, I even have all my teaching stuff. I even have the network that I cast over and everything. I even have stuff of my neighbors that enjoy the music, their daughter dancing. I have tons of stuff that I could use. Again, I know I'm giving away what I have right now because I know it comes from you, period.
Well, it's not giving anything away. I want you to present whatever evidence you have that are defenses in your case.
Right.
And you have certainly the right to do so. We do have an officer, though, that's been subpoenaed and is here for trial today, and we have to respect their time as well.
Yes, indeed.
It is 9:45.
Mhm.
Can you be back here in half an hour with the documents and things that you need?
Yes, indeed.
Then let's do that. We'll hear your case at 10:15. That gives you an opportunity to get what you need.
Okay.
Okay?
Okay, cool.
All right.
All right. Do I just go?
You sure can.
All right, thank you.
Yes, sir. I apologize for the inconvenience, but appreciate your patience. Okay. Mr. Winkler, are we ready to go on Mr. Holloman? Okay, that sounds great. Just let me know.
I'm sorry. Go ahead. She's a witness, Your Honor, for a case. Norwood, Norwood.
Judge, I told her I'm going to the community center to do a few things. She's got my number.
You can throw it away. I need you to stay though and tell me on the record what it says. Can you hand me that file? All right, City of Kennesaw versus Colin Orton. Mr. Orton, I know you went to go get your drug screen done. You had told me under oath you're going to pass that drug screen. I think we have the results of it. Mr. Smith, what are the results?
He came back negative for all drug screens. Came back positive for alcohol.
Well, you told me that you were going to pass the drug and alcohol screen, and you have not. I'm very disappointed that you weren't honest with me about it. You're here for underage possession of alcohol, and this tells me that you thought so much of that charge that you continued to engage in that behavior after arrest and before your court date. So I'm very disappointed. Is there anything you want to tell me?
It's been multiple days and it was with my parents under that. I didn't think it would come up today.
You
I
should have been honest with me.
Yeah, I apologize. I'm sorry.
Well, unfortunately, that's a little bit too little and too late, and I apologize for this. You are no longer eligible for the diversion program because of your lack of truthfulness, and I'm going to go ahead and fine you in contempt of court and sentence you to 24 hours to serve. Officer Helton, if you'll please take him into custody at this time. At the end of that period of time, you'll be released, given a new court date to come back for arraignment on your case. Unfortunately, the diversion program is no longer an option. I'm sorry, sir.
The door closed. Should be right.
Do you have a cell phone or anything in the lock?
I have. Got enough over there right now. I'm gonna let him sit here. No. Okay. Okay. Let me go catch Hilton before they fall out.
There you go in the back.
Yeah. City of Kennesaw versus Devin Holloman. Good morning, sir. How are you?
Doing good, Judge. How you doing?
I'm well, thank you. Let's see, Mr. Holloman, it looks like you've spoken with a solicitor about your case. And you'll be entering a plea of guilty to improper U-turn. And it looks like you've already paid the fine for that of $320. Is that correct?
Yes, sir.
All right, please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, I'm going to show you a few documents that talk about your constitutional rights and go over those with you. First, I'm showing you what's been marked waiver of right to counsel. Have you had the chance to review this document?
Yes, sir.
You have the right to an attorney to represent you in this case. If you are unable to obtain an attorney, you may request a court-appointed attorney. By signing this document, you're waiving or giving up that right and moving forward with your plea today. Do you wish to waive your right to an attorney in this case?
Yes, sir.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. I'm showing you what's been marked waiver of jury trial. Have you had the chance to review this document?
Yes, sir.
You have the right to a trial by jury in this case. Do you wish to waive that right and continue with your plea?
Yes, sir.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. And I'm showing you what's been marked a plea proceeding record, acknowledgement, and waiver of rights. Have you had the chance to review this document?
Yes, sir.
Do you wish to waive the rights that are explained in this document?
Yes, sir.
Is this your signature?
Yes, sir.
I'll accept your waivers. All right, and is this the plea that you'd like for me to accept?
Yes, sir.
Is
Please.
anybody making you or forcing you to enter this plea today?
Not at all.
Are the allegations of the city with regards to the charge of improper U-turn true and correct?
Absolutely.
All right, well, I'll accept your plea of guilty to improper U-turn and the null pros of improper lane change and open container. I find that the plea is freely and voluntarily given and that there's a factual basis for your plea. The sentence of the court is a fine of $320, which has already been paid, and that will complete and close your case today. I wish you good luck, sir.
Appreciate you.
Yes, sir. All right. All right, so Johnson was on that one, but he's got another one at 10. So he needs to remain. I have not yet called the 10 o'clock calendar. We'll go ahead and call that right now. Let's see, Nehemiah Bryant. City of Kennesaw versus Nehemiah Bryant.
It's an arraignment.
Yeah, still not here, so. Yeah, warrant shall issue.
They paid.
Oh, they did? Okay, I'll take care of that. Antonio Campbell. Good morning, sir. How are you?
We'll talk with the officer about that. That's going to be a trial.
All right. Mr. Campbell, do you know about how long it'll take that you need to present your side of this case?
I guess 5 minutes, maybe.
Okay. Do you have any witnesses that you've subpoenaed or brought to court today for you?
No, sir.
Okay. Well, it's important that you know a few things. You have the right to remain silent. You have the right to not testify against yourself if you do not wish to. You have the right to an attorney to represent you. You have the right to present your own evidence, witnesses, and defense in this trial. You have the right to cross-examine the witnesses of the state and to present your own evidence in your defense. The state has the burden of proof, of proving guilt beyond a reasonable doubt, and you are presumed to be innocent until proven guilty. Today is a trial date. It's a day for trial in your case. You'll have the opportunity to speak with the solicitor before we do go to trial, and you may be able to work your case out. It's important to know that if you're found guilty, that the sentence of the court may be up to the maximum allowable under law for that charge. So just take that into consideration that may be different from what the solicitor is offering if you enter a plea. Looks like the solicitor is talking to the officer in your case and will want to talk to you in just a few moments. As soon as that's been completed, we'd be ready to call your case and go ahead and have your
All right.
trial this morning, okay?
Yes, sir.
All right. Thank you so much, sir.
Thank you.
Romez Coleman. Romez Coleman. Any announcement in that one?
It's an arraignment.
Okay.
It's on the right to-
Mhm.
that's for this one.
Warrant shall issue.
It's Jack Holmes' case.
That's Jack Klein's case. Tell him the warrant's been issued. City of Kennesaw versus Jonathan Norwood.
That's for this one, lawful on that case. I think that, civilian witness here on that case did well, but I'd like to get the lease as well as the.
Okay.
Also on that case.
Madam Clerk, do we have any communication from Mr. Norwood? Does he have an attorney?
Yes, sir.
And it is 11 minutes after 10 o'clock. This is on a 10 o'clock calendar. I'm going to give him until 20 minutes after 10. If he hasn't arrived at that point in time, we'll issue the bench warrant and release the witness and the officer. City of Kennesaw versus Christelle Pierre Louis.
It's 11.
That is 11. All right. I think that's it for the 10 o'clock calendar. Mr. Solicitor, if you'll let me know when trial is ready.
Yes, sir.
Good morning, ma'am. What case are you here for? At 10? Anders, okay, yes. Miss Sinclair's case was actually at 9. Are you Miss Sinclair? Okay. Well, I'm glad that you're here because we had just issued a warrant for your arrest for failure to appear. So I'm glad that you're here. You'll need to speak with the solicitors about your case and be ready. It is set for trial today on the charge of failure to obey a stop sign. We released the officer already because they were here on a timely manner. So you need to speak with the solicitor and we can either well, you wouldn't have because you received a notice when you were in court last. It told the time and date and location of this trial. Okay, ma'am, is that my fault? Okay, then that's enough. You just need to stay put, speak with the solicitor, and if we need to call the officer back off the road for your trial, we'll do so. Yes, please. We are going to try to reach out to your court appointed attorney. We'll see if we can reach him and see what it is.
If not, I'm just trying to get this over with, so. It's just a stop sign. I was pretty sure I didn't pass one up, but at this point, I'm just trying to get back to it. So,
I understand. Well, it's up to you. If you want to wait for your attorney, you can do so. If you want to speak with the solicitor about the early, but after your attorney, you can do that as well.
yeah, I'd rather just do that. It was just a stop sign, you know, I'm sorry. It's not nothing.
Okay, that's no problem. Then you can speak with the solicitor and they'll talk to you in just a moment.
We still calling you.
Pardon? I know. Where is Mr. Crawford? He is, he'll be here. He's got a few minutes.
I think they control it up there on the bench.
Good morning, Ted. How are you? I've been waiting for Mr. Bentley to retry it. I haven't spoken to him yet. I'm waiting in line. I'm queued up, but, yeah, I remitted that, the FTA last week. And I thought this was gonna be an arrangement calendar. but- Right, yeah, well, I appreciate it. Thank you very much, Judge. See you shortly.
Judge, Ms. Sinclair is going to be. Judge, it's 10:20. Can I release the witnesses online?
City of Kennesaw versus Norwood, Jonathan Norwood. Mr. Norwood, you just saved yourself a bench warrant by about 15 seconds. All right.
Step on that.
Okay.
Judge, you gave me some property till 10:15.
I did, and I see that he is not here.
5 witnesses waiting on that case.
I believe there are. Yeah. How many of y'all are here for Crawford? Oh, bless your hearts. All right. Well, I think superheroes are due a little bit of leeway, so we'll give them another minute or two. But I appreciate your patience. He did. Oh, Linda. He said he had to find a phone booth. That's funny. Bless his heart. I believe he just has one charge. Yes. Must have been an accident. not think the shredder would miss. Ms. Sinclair, if you'll come up to the podium. All right, and ma'am, just to confirm on the record that you wish to move forward with this case without your attorney present.
Yes, sir.
Okay. And you have a citation for failure to stop at a stop sign, and you wish to enter a plea of no contest. Is that
Yes.
correct? All right. Please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, I'm going to show you a few documents that talk about your constitutional rights and go over those with you.
Okay.
First, I'm showing you what's been marked waiver of right to counsel. I know we've kind of already covered this, that you're wishing to move forward today without the assistance of counsel. Is that correct?
Yes, sir.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. Showing you what's been marked waiver of jury trial. Have you
Yes.
had the chance to review this document?
Yes, sir.
Do you wish to waive your right to a trial by jury?
Yes.
Is this your signature?
Yes, sir.
I'll accept your waiver. I'm showing you what's been marked a plea proceeding record, acknowledgement, and waiver of rights. Have you had the chance to review this document?
Yes, sir.
Do you wish to waive the rights explained in this document?
Yes.
Is this your signature?
Yes.
Okay, I'll accept your waiver. The solicitors made a recommendation in your case of a fine of $160, 12 months probation. Probation can be terminated immediately upon payment in full of the fine. And if paid in the next 30 days, then the probation fee would also be waived.
Understand.
The only thing I would add would be to pay all fines and surcharges at least in the first 6 months of that probation.
Oh, it'll be paid by next week. I
Okay.
get paid next week, so not a problem.
Perfect. Is this the plea you'd like for me to accept?
Yes, sir.
Are you a citizen of the United States?
Yes, I am.
Is anyone making you or forcing you to enter this plea today?
No, sir.
Are the allegations of the city with regards to this charge essentially true and correct?
Yes, sir.
All right, I'll accept your plea of no contest to failure to obey a stop sign. I find that your plea is freely and voluntarily given and that there's a factual basis for your plea. The sentence of the court is a fine of $160, 12 months probation. With the terms and conditions of probation we just discussed, you will need to meet with probation briefly before you leave today. So if you'll have a seat in the courtroom, they'll call you back in just a
Okay,
moment.
thank you.
I wish you good luck.
Yes, sir.
Yes. I have a bag and a case that's outside. They said they have to leave to bring that in. Okay.
Okay, have you already spoken to the solicitors? You need to speak to
Before I left, yes.
Yeah, but witness also. I think now that's probably for you over there.
City of Kennesaw versus Jonathan Norwood.
Morning, Your Honor.
Good morning, sir. Let's see here. Looks like you had a citation for failure to obey a stop sign. And the solicitors made a recommendation to dismiss that charge.
Yes, sir.
All right, I'll sign off on it, and that case will be dismissed. And so anyone who's subpoenaed on that case also can be excused at this time. I wish you good luck.
Yeah, thank you very much.
Yes, sir. Is that the problem? See what the officer might do. Hubbard, yeah. I think everybody's here on the Crawford case. Yes, yes, it did. You said Mr. Campbell's fixing the food? Okay. So we'll address Mr. Campbell's case, and then I think then we'll be ready for Mr. Crawford's case. Yeah. Jack. Oh, Jack, big Jack. So, okay, fantastic.
That's what happened. So it's a city ordinance. 1870. What's the difference between? 6250.
Minus.
162.50.
That's the. Search. Seven.
That's 129.62. Mr. Wingwood.
Okay, thanks.
City of Kennesaw versus Antonio Campbell. Good morning, sir. How are you?
Doing well. Your Honor, how are you?
I'm well, thank you. Let's see, Mr. Campbell, you have citations for too fast for conditions and child under 6 years of age without proper restraint, and it looks like you wish to enter pleas of guilty to both charges. Is that correct?
Yes, sir.
All right, please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
I do.
All right, I'm going to show you a few documents to talk about your constitutional rights and go over those with you. First, I'm showing you what's been marked waiver of right to counsel. Have you had the chance to review this document?
Yes, sir.
You have the right to an attorney in this case. By proceeding without an attorney, you'd be completing your case without the assistance of counsel. Do you wish to waive your right to an attorney in this case?
Yes, sir.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. Showing you what's been marked waiver of jury trial. Have you had the chance to review this document?
Yes, sir.
Do you wish to waive your right to a trial by jury in this case?
Yes, I do.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. I'm showing you what's been marked to plead proceeding record, acknowledgement, and waiver of rights. Have you had the chance to review this document?
Yes, I have.
Do you wish to waive the rights explained in this document?
Yes, sir.
Is this your signature?
Yes, sir.
Okay, I'll accept your waiver. The solicitors made a recommendation in your case of a fine of $210. Would you be able to pay that fine today?
Yes, sir.
Is anyone making you or forcing you to enter this plea today?
No, sir.
Are the allegations of the city with regards to these charges true and correct?
Yes, sir.
All right, I'll accept your pleas of guilty to too fast for conditions and child under 6 years of age without proper restraint. I find that your plea is freely and voluntarily given and that there's a factual basis for your plea. The sentence of the court is a fine of $210 to be paid to the clerk today, and that will complete and close your case. I wish you good luck.
Same to you.
Right. Mr. Winkler, are you ready?
Yes, Judge.
All right, we'll go ahead and call the case of the city of Kennesaw versus Kevin Crawford.
Your Honor, I would think that we could try these two cases together, except two citations. One is 2104-0521 and 2104-0531. They both occurred on April 9th, about 7 hours apart. And they're both notice violations. And I would ask that we just try those both together.
Okay. Mr. Crawford, do you have any objection to those for the evidence of both of those being heard at the same time?
No, sir.
Okay, then that's what we'll do. Now, as the solicitor mentioned, Mr. Crawford, there are two charges here. They're both two counts of the same offense, which is violation of the city ordinance 18-78, which is with regards to sound control and creating a nuisance with sound. You've entered a plea of not guilty on both of those counts. And so this is the day for trial. What will happen, as I mentioned earlier, is first the solicitor has the opportunity to make an opening statement. You'll have that same opportunity. An opening statement isn't evidence or testimony. It's really kind of like the roadmap for where the case is going that you're going to present. I don't know any facts of the case. I don't hear about them beforehand. So this case is new to me, and that's the way it should be. So I want you, in the opening statement, the solicitor is going to tell me what generally he believes his evidence is going to prove, and you'll have the opportunity to do the same.
Okay.
At that point in time, then the city will put on its case in chief. They'll call their witnesses, swear them in, and they'll deliver their testimony and evidence. Each witness, you'll have the opportunity to cross-examine after they've given their direct testimony. After the city has called all its witnesses and presented its evidence, it will rest. And then it'll be your turn at that point in time to call your witnesses and present your case and evidence. The city will have the opportunity to cross-examine any witness that you call during your trial as well. At the time that you would rest, then the final aspect of the trial is what's called a closing argument. In a closing argument is where both you and the city will have the opportunity to present its legal case, to argue any case law precedent, in this case, any law regarding this local ordinance, and show how the evidence you've presented would support your position on this case. Okay? All right, then let's go ahead. And Mr. Winkler, would you like to make an opening statement?
Yes, Judge, just briefly. Judge, on case 0521 on April 9th, 2021, 12:55 a.m. I believe the evidence showed that the accused was playing music from a device that was located on his front porch. The music you heard at a distance greater than 500 feet. And the second case, 0531. This was at 7:15 on the same day. Officers went back out there for a noise complaint by the neighbors, and they made contact with the resident and refused to reduce his music volume. It was being played from a boom box, clearly audible from a distance of 68.3 feet. That's what we wrote down. So sure did. Just further, there were 2 prior citations to this gentleman, one on January 26th of 2021, and one on November 21st of 2021, which we're going to introduce the dispositions on those 2 cases, Judge, to show that this is the third and fourth offense.
All right, Mr. Crawford.
Jesus, where to start? Not really even too sure where I go with that outside of what he said.
Well, at this time, the best way, and I can't give you legal advice.
I got you.
But I'm giving you some procedural
Yes,
advice.
yes.
This is where, like, if you're reading a book, this is like what it's going to be on the back cover. You're going
Okay.
to tell me in general, Judge, I believe my evidence is going to show A, B, and C. And
Yeah.
that's why and we hope that will prove and show that we are not guilty of this offense. And I don't believe the state can prove its burden.
Okay.
Okay. So just tell me kind of that in general, because this isn't evidence. This isn't sworn testimony and it's not evidence entering. You're just kind of giving me the roadmap of what I can expect to hear.
Yeah.
Does that make sense?
Yes.
Okay. Carry on.
Okay. So the boombox is not a boombox. It's actually a system that I got from a graduation present, which I graduated in 2002, mind you. The feet that they have measured at, the decibels that it is to be measured at, I have evidence here that over 9 times they've come by and I've been under that each time. Even with what they have now, I'm still under those decibels. Yes, you can hear it, but you can also hear me on my cell phone having a conversation outside. So I believe I do have evidence to show that I'm not a nuisance, but I do like to celebrate every day and I'm just willing to do so. I do know personally there's not a lot of people that like to do that. It's just who I am. It's what I do. That's it.
Okay. Very well. Go ahead and call your first witness. Oh, I think we've got a microphone set up there. Officer, if you'll please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
I do.
Please state your full name for the record,
Aaron Bright,
and where you're employed,
the city of Kennesaw,
and how long have you been employed there?
3.5 years.
Any law enforcement prior to that?
No.
And does the city of Kennesaw provide police enforcement 24 hours a day, 7 days a week, 365 days a year?
Yes,
Were you working on April 9th, 2021?
yes,
Did you come in contact with the defendant?
yes.
Can you identify him for the record?
Mr. Crawford,
Mr. Crawford, he's wearing a shirt with flowers on today. And black pants. There's what the record reflects he's identified the defendant. And did you come in contact with the defendant at his residence at 2540 Ridge Crest Drive?
yes,
And that location within the city limits of the city of Kennesaw?
yes, it is.
What court would you observe that?
So we responded to a noise complaint to his residence right after midnight. So when we got there, we parked pretty far back and we start walking up to the residence. As we're walking up to the residence, we can hear the music. I did have the decibel reader. It was under the decibel. Then we found out there was another code section, which was the no amplified sound at 50 feet in distance. And we measured it and it was over 50 feet in distance.
So you charged him with, no amplified sound shall be permitted after 10 PM on Sundays and Thursdays, or after 11 PM Friday and Saturday. This was beyond both of those times, correct?
Correct.
And that does not have a decibel level limit. That is just any audible sound at that time, correct?
Correct.
Over 50 feet. And officer, in this case, you could actually hear it from over 200 feet away, is that correct?
It was approximately around 100.
And what was the device that was playing from?
A speaker. It's like there's a sound system by the front door and then there's speakers. That were-
So he had like a boombox device and attached speaker.
Yes.
Appreciate what I'm gonna mark as exhibit. One. This is a copy of the disposition from a case in November 21st, 2020. You recognize that?
Yes.
And is that a true and accurate representation of his disposition?
Correct.
And that disposition shows that he played guilty, is that correct?
Correct.
And this is the disposition from January 2016. You recognize that?
Yes,
Is that a true and accurate representation of this disposition from that day?
it is.
And that disposition shows that he.
Correct.
So that's something. That I'd like to introduce exhibits 1 and 2 of the evidence.
Okay, Mr. Crawford needs to have a chance to review those.
Are these the nights when she was there?
Those are the 2 prior ones.
When she was there? Oh. So 2 prior ones, you mean like 2 that have nothing to do with today?
2 that happened prior to today. So 2 that belong to today.
'Cause what it sounded like you just said was the court cases that we were. You mean what I did in front of the judge?
Yes,
Oh,
those are just the dispositions of ones in prior, did prior,
oh, why are we bringing these up though?
because the statute requires that I prove what number of events this is.
Oh, gotcha. Okay.
Do you have any objection to these coming in as evidence?
Yes, I do.
Okay, what is the nature of your legal objection?
They don't have anything to do with this particular case?
Okay, that would be an argument of called relevance.
Okay,
Now, unfortunately, it actually is relevant,
gotcha.
and I'll tell you why.
Oh, go ahead. Yeah.
Because the city ordinance that this case is being brought under has different requirements for how many offenses it's been.
Mhm.
And the fact that what they're trying to show is that this is more than your second offense.
Mhm.
The statute says if it's a first offense, you do X. If it's a second offense in 12 months, you do Y, and has other things for further offenses.
Right.
So that's why it would be relevant.
Yeah, I was just taking a shot, that's all.
That's, hey, you miss 100% of the shots you don't take. So it'll be admitted over objection. All
Okay.
right, okay. Okay. Do you have any questions for Officer Bright?
I don't, no,
All right. Can this witness be excused?
Yes, sir.
Then you may be excused. Call your next witness.
This time I call Officer Smith. And Judge, this is on the second case, 0531.
All right, if you please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
Yes.
All right.
Please take the full name for the record.
Matthew Smith,
And where do you work
City of Kennesaw Police Department,
and how long have you been employed here?
approximately 4 years.
Any law enforcement prior to that?
No, sir.
And does the city of Kennesaw provide police support 24 hours a day, 7 days a week, 5 days a year?
Yes.
Were you working on April 9th, 2021?
Yes.
Did you come in contact with them? on that
Yes.
day?
Yes.
And you identify him as correct?
Someone wearing a flowers on the shirt with black pants.
And did you encounter him, his residence at 2540 Ridge Restaurant?
Yes.
And is that within the city limits of the city of Kennesaw?
Yes.
Tell the court what you saw.
I was dispatched to the residence for a noise complaint. When I arrived, I could hear music playing from speakers, which were positioned on his porch or just in front of his front doors. I used my LiDAR to measure the distance from where I was standing, that I could hear that music clearly, which was 68 feet, 68.3 feet. And at that time, just past 7 in the morning, prior to 8 o'clock, that ordinance is that the music not be audible from 25. He was in clear violation. I explained to Mr. Crawford what the ordinance was. We spent time reading it together, and he still disagreed and refused to turn the music down. By the second.
So prior to 8 a.m., any audible noise that's being created before 8 o'clock a.m. is 25 feet.
Yes, sir.
What type of device do you use?
There were 2 square speakers with cords going inside of the. I don't know what device was playing the music, but these were 2 boombox style speakers.
Anything else you'd like to come forward?
No, sir.
If that's all.
Okay. Do you have any questions for Officer Smith?
Yes, where the proof of the measurements are of the distance plus the beep, the decibels. On that same law that he brought up, there's still other decibels that you're allowed to have. There's one that is at 80.
Let's
Okay.
ask one question at a time.
Oh, okay,
Okay,
sorry.
so ask him your question.
Okay, the proof of the decibel reading and distance.
Okay, sir. And the specific code section that I charged for does not have a decibel requirement. As for proof of the distance, that would be on my device.
Okay.
I would ask to see the body cam footage.
I do not have
Do you have your footage with the body camera with you?
No,
The footage.
we may have it. Case file.
Is this it? I think it is in the file.
Did I have it here?
You do? Oh, we have it as well. There we go. Let's see, it looks like on this, we've got 3. Do we know which file it is?
I think it's possibly on video too at 3:13. Oh, wait, it's got a time mark at 24:50. On the video, it's marked 0531.
Okay, that's not on anything here. I've got, you can see on the screen here the 3 videos that come up on that disc.
That's fine.
See what it does.
If we were given these as 2 videos, one for each case. So we may want to try to use this one.
Is that
So
the
we get
right?
to the time.
Okay.
I had to note that around 24:50.
Okay. Well, right now it's his cross-examination. He's asked about the video. The officer has indicated it's on the video, so we'll, yeah, take that one out. Let's see what pulls up. Okay, once again, here are the 3 files that are listed on that CD. Appear to be the same ones. Do you know what video it is you're looking for? That would be your body cam. Are you familiar with this, officer?
No, sir, I'm not familiar.
Okay, well, I tell you what, I'm gonna start the first one and you tell me if this is that. Do you recognize this video? It's 4/9/7:15 a.m. it appears.
Yes, sir. This looks correct at exactly what point I do measure the distance. I do not.
Okay.
We got a call about the music.
Yeah, you guys came by this morning already.
Right.
Uh-huh.
And what did they talk about then?
They gave me a citation that had no numbers, no nothing, anything on there. And then I read it, and I can show you with my phone right now. And you're supposed to be
Okay.
25 feet off of my property when you measure. And I was sleeping when they came by, all illegal. And so I've already made calls to the proper authorities to go ahead and check in on it.
Okay. Let's get out of the road.
Right now?
All right. So there is a decibel level. However,
So you're standing in this.
Mr. Wingler, I hate to interrupt you, but he's not your witness right now. He's actually on cross-examination. He's Mr. Crawford's witness. So, Mr. Crawford, is this the video?
I don't see him, so I don't know.
Okay, well, it's his testimony. Is this your video?
Yes, sir, that is.
Okay, so he had answered your question of
Yes.
saying that the distance could be determined from the video. Is there a place in the video you'd like for me to get to?
I'm sorry, sir, I don't know exactly when in the video I take that measurement.
Okay. Approximately how long were you on the scene?
I believe it was close to an hour that I was on.
Okay. I don't think really it's in anyone's best interest to watch an hour of this video. Is there a place in the video that you recall where you address the distance?
It maybe towards the end, before I start handwriting the citation, I most likely would have taken a minute.
Okay.
Just run the counter, 24:50.
Oh, there it is.
All right.
We're at a distance of 68 feet, 68.3 feet. And it's clearly audible.
Okay.
Video appears to be frozen, but I should be able to see it on it.
Okay. And is that the reading that you took?
Yes.
Okay. Did that answer your question?
No,
Okay.
Um,
Ask your question then.
okay. At that I need the evidence that's outside, Your Honor.
Okay.
I have the
Well,
case in my cell phone.
For a question?
Yes, sir.
Okay.
Should I go get it? Okay.
Officer Helton, can you help him get his evidence? And Mr. Klein, can we take care of you in the meantime? Is there anything that we need to do for you?
I just need you to sign a bind over motion.
Just bring it on up while they're bringing that in. Already up here.
The case backpack and the cell phone.
There it is.
Yes, please.
And are you paying the failure to appear?
It's been reviewed.
Okay. There we go. You got to take care of it. Absolutely.
Thank you very much.
You're welcome.
Cell phone. I didn't.
Mr. Storms. Thank you, sir.
Thank you. Mr. Crawford, where are we going with this?
The measurements that he has at the 68.3 feet on that same law, it has within my mark from my sidewalk. And I have the measurements which goes
Okay.
into my neighbor's
that-
yard.
Now, that would be evidence that you'd present during your time to present evidence.
Oh, I thought that's what this was. Oh,
So this is your opportunity to ask the city's witness, Officer Smith, any other questions about his testimony.
gotcha. Okay, so the next question would be, under that same hearing that he was hearing, there's also a car that drives by at that same moment, which also is louder than the very speakers. And he said that, oh, sorry, one question at a time. Go ahead.
Okay, that's fine. One question. So what was your question?
Oh, the question is that measurement accurate with being a nuisance at 68.3 feet when you also have a car driving at the same time past you, which is equally louder than the music?
Okay, that's the question.
Okay, I will say that the music from where I was standing, greater than 25 feet allowable was clearly audible.
Okay. What's your next question?
I don't believe I have any more questions except for, why would you be doing this to me?
Okay. Yeah, that's not really a proper
I
question.
that's only what I had, sorry.
No, that's okay. That's all right. Then any redirect for Officer Smith?
Yes.
And we have this video. Did you want to move that into evidence? Yep, that's true. Okay, then so be it. Okay, any other redirect? Okay. Can this witness be excused?
Yes, yes, sir.
All right, thank you so much. Call your next witness.
Officer Alvarez.
Raise your right hand. Do you swear or affirm the testimony you shall give in the matter that's pending before this court shall be the truth, whole truth, and nothing but the truth?
Sworn and affirmed.
All right.
What's that name, correct?
Officer Michael Alvarez,
And where are you employed?
City of Kennesaw Police Department.
And how long have you been over there?
This will be my 6th year of policing.
And in law enforcement prior to the city?
No, sir.
And does the city of Kennesaw provide police enforcement 24 hours a day, 7 days a week, 365 days a year?
That's correct.
And were you out at the residence of 2540 Ridgecrest Drive on April the 9th?
I was.
Did you encounter the defendant out there?
I did.
Tell the court what you observed.
I responded as a backup officer to a noise complaint at the listed location. Both times. When I arrived, we heard music. I'm not entirely sure what type of music it was, but we heard music coming. I could hear it as soon as I exited my vehicle. At first, where I parked my vehicle, it didn't seem remarkably loud. However, as we got closer, it started to get more and more. The volume increased. And we attempted to talk to Mr. Crawford about the violation and explain to him which portion of the city ordinance he was in violation of, why he was in violation of it. We attempted to give him an opportunity to remedy the situation outside of receiving a citation. Mr. Crawford refused any recourse other than keeping the music going. Therefore, Officer Smith issued him a citation for violation of the city ordinance.
Did you estimate the distance? Did you do the measurements?
No, I didn't. I am familiar with the device that was used in measuring. However, it's a LiDAR. It uses distance as a function of time to generally get the speed of a vehicle. However, it can be used, and when in calibrating, it's used to measure a distance from the point in which the individual is operating the equipment is standing to a point that it's pointed at.
Are you able to justify that you estimate the distance to be greater than 50 feet?
At the time in question, it was violations more than 25 feet.
All right. Do you have any questions for this officer?
Yes. I have it. Oh, are you a supervisor?
No, sir.
From what I understand and from what I've been taught from other supervisors, only supervisors have the machines that can properly measure your decibels and distance. I only know that because I have paperwork of over 9 times of them doing so with me being within the law.
It is, but I think there may be a response to it at the same point in time.
At the date in question, Mr. Crawford, it wasn't a question of whether or not you were in a decibel violation, because as we explained to you on scene, there was no decibel violation. It's if a sound is audible at a distance of 25 feet or greater. And anyone can operate the decibel meter. You are correct. The supervisors are the one that possess it. The device that we used was a LiDAR, and my knowledge, any officer that's certified it at the state, or excuse me, the city of Kennesaw has and is authorized to operate it in the state of Georgia.
Okay. Any other questions?
With this measurement, thankfully we do know each other in a different way. Would you say that you saw a nuisance when you showed up?
I don't know that my opinion is relevant.
No further questions, Your Honor.
Okay. Any redirect? All right. Can this witness be excused?
Yes, sir.
Is that okay?
Oh, yes.
Okay. Officer, thank you so much. You may be excused. Call your next witness.
Officer Willard.
Please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
I do. Clerk Andrew Woodard. And where do you work? City of Kennesaw Police. And how long have you been employed there? 8 years. In law enforcement prior to that? Yes, I've been a certified officer since June of 1998. Kennesaw Fire Police Enforcement Services, 24 hours a day, 7 days a week, 365 days a year. Yeah. On April 9th, 2021, you have, you get the residence of 2540 Rich Crest Drive. Yeah. And you observed the defendant there? I did. What you saw out there?
I responded as the supervisor for Officer Smith's case. When I arrived, you could clearly hear the music as I got out of the vehicle. We discussed the previous citation that he had received earlier that evening and spoke to him about that. And because he still refused to turn out his music, he issued a second citation based on the distance here. Based on.
All right, so the music you heard all the way greater than 25 feet. Yes. That's all the questions I have.
Okay. Any cross-examination for this witness?
When you appeared, did you find it to be a nuisance? Is there evidence of the complainants that have made these calls? Are we allowed to see these evidences?
Yeah, I think that the officer may not have that knowledge, and if you needed that knowledge, that would have been something you could have subpoenaed or asked for in discovery regarding your case.
Right, gotcha.
Okay. So you could ask the officer, does he know who filed the complaint?
Yes, do you know who filed the complaint?
I do not.
So anyone who doesn't even live in Georgia who knows that I play music could, who has a grudge against me, just randomly call from Texas and say that I'm playing music and it's a nuisance.
Yeah, I'll sustain that objection because that calls for a speculative answer. There can't be a definitive yes or no
Okay.
answer there.
I'm guessing sustain means equal.
Sustain mean that the objection is good and he doesn't have to answer that.
Gotcha,
question.
gotcha. No further questions, Your Honor.
Okay. Any redirect? Can this witness be excused? Okay, thank you so much. Call your next witness. All right, okay, so it is your turn now. Now you can call yourself as a witness and offer your own testimony. You can call another witness and offer their testimony and ask them questions, whichever way you want to proceed.
Okay. All right, since I don't know what I'm doing, the paperwork that I have here, in order to present it to you, do I need to make myself a witness?
Yes.
Okay,
So first raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
yes.
Okay, go ahead and tell us what you want what you want the court to know.
Okay, first off, when I first started this, it was for Christmas. I used to make dance videos for Christmas and everything. That I decided, well, let's not just dance, let's do this. So I've been dancing in my backyard with the same equipment for 7 years, okay? On this particular time, when I came outside on the first day, the police were called. In this paperwork that I have right here, it shows that I've talked to 3 different supervisors who taught me what I was supposed to do and not do. Upon that, the very supervisor who dropped this paper off, he told me, when anybody calls for this property, I'll tell them not to respond. That didn't happen. So each time somebody came, what did I do? I've talked to the supervisors. They've measured me. We've talked, we've sat here and we've talked about this many times. They told me I'm okay, but people have a problem and you have to come. And he said he would tell you not to come. So obviously a guy looking like, you saw how I came in here, looking like that, talking to them the way.
Yeah, the rule of evidence that he's talking about is a rule called hearsay.
Yes.
Hearsay is an out-of-court statement that's offered in court to prove the truth or veracity of that statement.
Yes.
You can't, hearsay is not accessible, so you are not.
I got you.
Excuse me, is not admissible unless the witness, unless you have as a witness, the person who made the statement.
Yes.
So unless you've got this officer that you're talking about and identified them and they're here to testify for
Okay.
you today, offering what they said outside of court would not be admissible.
I just have the paperwork. That's it. I don't have them.
Oh, okay.
I'll tell, okay, so without the hearsay portion of it, we do have documents that have shown over the years of people calling, I've been fined no citations. After I decide, guys, I'm within the law, then I start getting attitudes of different people doing what? Keep coming, which hurts somebody. So of course I'm going to try to stand up for myself and what I'm doing. Now, with the machine that I'm using, it's these two speakers. This. It's subwoofer, which is blown. It's just the power source. This speaker is blown. It just has to stay on there. So it's running from the left speaker only, not even capable of being a nuisance, but you're going to hear it regardless. If I'm outside, you can hear me talk on my phone from the driveway. This is my equipment. I would have brought my laptop, but it's so cracked I couldn't get it in my backpack.
Okay, sir, it's okay. Take a deep breath. It's all right.
I don't do this to be a nuisance because I've been entertaining for over 20 years. Over everything I do, I even broadcast it so other people are enjoying it around the world, not to piss off my neighbors. And I have documents that show I haven't been doing that yet. After a while, everybody gets annoyed. And now I'm at the opposite end of that annoyance. And it's coming after me. I don't find it to be right. That's it.
Be careful. Let's get that up for you.
Thank you.
Okay. So is there anything else you want for me to know about this? I understand now you've told me where the music was coming from and what your situation is.
Yes, I do.
Okay.
On this, I do have actual footage of very neighbors who are present listening to the very music that isn't a nuisance. I have the measurements of where it should be standing, of getting these measurements from. And in each thing that I've seen, I haven't seen those positions be met.
Okay, now just videos of someone enjoying music or enjoying what you're doing, unfortunately, is not going to be relevant.
Okay.
The way that the city ordinance is written is it says that if the music is audible from this source within 25 feet with this time of day,
yeah,
then it's violative of the ordinance. And it's just called a nuisance. It doesn't really necessarily mean that you are subjectively offending anyone. It just is written the way it is so that if music or any other noise is heard within this distance, it's violative of the ordinance. So I certainly appreciate that others may appreciate very much what you do, and I don't discount that whatsoever. However, it's not relevant to what we're here today to determine.
Right.
What we're here today to determine are the facts. Did you or did you not violate this ordinance?
Yes.
Now, the city has the burden of proof. They have to prove that you did beyond a reasonable doubt. And so what your job is as pleading in your defense would be to present evidence that would make that burden of proof not be reached.
Yes,
It would create more than a reasonable doubt.
yes,
So the second evidence you said you had of recordings you've made from the prescribed distance that would not show not a violation, that could be relevant evidence if it was made at the same time that the officer's designation or the officer's video was made.
it was not,
It was not.
no prior.
Okay, it was made before then?
Yes,
Okay. So I mean,
meaning
so it
like
could have been a
after,
different
sorry,
time.
go ahead.
So it could have been a different time of day. The volume levels may have been different.
Oh, no, not that measurement, like the actual feet of measuring, like from the distance to use the decibel reader. Like I have like the feet, like I measured out with the,
You measured out the feet and
The
that's,
tape,
and that's
yeah.
less than 25 feet.
no, the 50 feet plus the 25 feet of where
Well, it
those are
wouldn't be a
taken from.
plus. The way the ordinance is drafted is at certain times, it's 50 feet.
Yeah.
At certain times a day, it's only 25 feet.
Mhm.
So it's a much shorter distance. It doesn't add the two together.
On both of those, I'm not sure if you know about it. On that same website that we've gone, they both have different brackets. And on that second one from the 25 feet, it still has audible decibels on there used from the same machine, but you have to use a different system to read it because it's not decibels, it's a different.
I
I don't
understand
even
what
remember
you're
the
saying,
name
but
of
I
it.
think you may be looking at at a different portion of the same code. It's a rather long.
Yeah, oh yeah, it's a lot on there. Yeah, yeah.
It's a long ordinance, and the part that this case is brought under says that boom boxes or any similar device shall not be operated in a public place or public right of way in such a manner as to be plainly audible at a distance of 50 feet in any direction from the operator between the hours of 8 a.m. and 10 p.m. Between the hours of 10 p.m. and 8 a.m., such equipment shall not be operated in such a manner that it is plainly audible at a distance of 25 feet in any direction.
Mhm.
So that's the operative part here.
Right.
Okay.
When from what we've read over and from Mr. Richardson that dropped this paper off, if you go down, there's audible decibel numbers, 2 different brackets that he showed me, 2 different ones. And
Yeah,
when
that's in a different part. There's a chart
Mhm.
for decibels.
Yes.
That's a separate violation, and you didn't get charged with that
Oh,
one.
go ahead.
They're different. It's a different charge.
Right.
And you didn't get charged with the one for decibel.
From what I guess what I'm trying to explain, Mr. Richardson, which was one of the first supervisors that came, which was at 7:15 yet again in the morning. When we were standing there together, he walked me through it. He even said only the supervisors have this because he was called to come to the scene. And we went through both measurements because he knew. And we were talking about, he's the same guy where he told me, again, I carry a Bible in my pocket. I was like, that's cool. And this is the guy who is teaching me, which is why I've been acting the way I've been acting and trying to hold the standard of, I know it's, yes, you can hear it, yet this is what I was taught by your supervisor.
Well, unfortunately, that's not gonna, you still have to abide by the ordinance. No matter what anyone's told you, you have to abide by the ordinance. Everyone does. That's just the way the law works.
Yeah.
So do you have any other evidence that would bring into question the measurement from the officer or the audibility of the music at the time the citations were written?
I have evidence that shows the different treatment of me when they have shown up, which would show why I've been brought to this point. I just don't know if that's able to be used here.
What do you have?
I have a video, plus I have postings that from other agencies on the internet, but I couldn't bring it because again, my laptop is too messed up. But I could show you the site where that video is, plus the video itself.
Okay, so what do you have actually with you today?
I put the video on my phone, so I do have the video. I just don't have, we can't look at the link that the video is on without the computer unless we pull it up from YouTube on here. But I do have the actual video that I'm talking about.
Your house?
Yes, yes.
Okay. Mr. Solicitor, have you seen the video?
I've not seen it. I haven't checked the video unless it's taken. Dealing with here today, these 2 times on 8 times.
Okay, he's objected to the relevance of the video and unless it was taken at the same time that either of these citations were written.
No, they were not.
Okay, when was it taken?
These just been taken pretty much since almost day one, almost. I didn't know I would have to be recording anything for a good minute. But it's just different cases of them coming to measure and then also leaving with me being within the law and them being fine.
Okay, yeah, and those times, I don't think you're here on trial for.
Yes, yeah.
I don't think that has anything to do
Yeah.
with today. So I don't think those are relevant. However, I do accept your testimony that there have been multiple instances where where police has been called to your home and you've discussed the matter with them, and most of which did not end up in a citation. These that we're here today with did end up in a citation.
Yes.
Okay. So what else would you like for me to know?
If I could, I'd like to call a witness.
Okay, before you call your witness, we have to finish your testimony.
Okay.
Mr. Wingler, do you have any questions for him on cross-examination?
No question.
Okay, so if you'd like to call a witness, you can do so now, and they can come right up to the corner there where the other mic.
Okay. Sorry, I don't remember your last name. What? I would like to call Officer Hilton.
All right, Officer Hilton. All right, if you'll please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth? All right, go ahead and ask your question.
Mr. Hilton, have you been to 2540 Ridgecrest Drive?
Yes, sir.
Have you been there to serve a subpoena for this courtroom?
Yes, sir.
When you were there, was the very music at question playing when you were there?
I do remember music playing, but I was not there for that.
So you were not there for a complainant on the day that you were sitting outside waiting for over 20 minutes for us to be able to come and get this subpoena paper.
Not just that at your house for a complaint. I was there only for certain people.
Okay. No more questions, Your Honor.
Okay, any cross? All right. Step there. All right, do you have any other witnesses?
Yes, one more witness, Mr. Sir John. Sorry, Mr. Waller.
Okay, sir, if you'll come up to the microphone. If you'll please raise your right hand. Do you swear or affirm the testimony you shall give in the matter pending before this court shall be the truth, whole truth, and nothing but the truth?
Yes, sir.
Okay, and what's your name, sir?
John Waller.
John Waller. Mr. Waller, thank you for being here this morning.
I want to apologize to the court for coming like this. I didn't know this. I received a call at the last minute saying this is going on and asking.
Yes, sir, I understand, and I appreciate you being here. That's quite all right. Go ahead and ask your questions.
Mr. Waller, do you know where the address 2540 Ridgecrest Drive is? Is your name John Waller? Have you in any past driven by the house and have found the music to be a nuisance? Have you at any? The relevance would come because the word nuisance it was used for Jesus, and I believe that he wasn't, yet even him was accused to be a nuisance when we know he was perfect. And if I can prove that, again, it's more abuse than being a nuisance, then I can be. Then my plea for innocence can be approved.
Okay, I'll give you a little leeway, but not a whole lot. Okay, so keep going.
No more further questions?
You don't have any more questions?
No, Your Honor.
Okay, any cross? Okay. Mr. Waller, were you present on the 9th when all this happened? Okay. Did you have any knowledge about the events or any firsthand knowledge of what happened at those events?
I don't know.
Okay. Well, thank you for being here. We appreciate it. Is there any objection to this witness being excused?
No, sir.
Okay. Mr. Waller, you're free to go. Thank you so much. Absolutely, you can. Okay. All right. Any other witnesses you'd like to call?
No, sir.
Okay, do you rest? Are you finished with any evidence you want to present in your case in your defense?
I would like to present the paper that does show over a year of calling with no citations.
Okay. Mr. Winkler, have y'all reviewed that paper? Okay. Okay, I'll admit this into evidence without any objection. Is there anything in particular here that you'd like for me to look at?
No, it just shows that they've talked to me many of times and I haven't been found guilty.
Okay, this is just a copy of the ordinance.
Yeah, yeah.
I see. Okay. All right. Anything else you'd like for me to know?
No, sir.
Okay.
Well, yeah. Everything I do is not for the purpose of being what they say I am. That's it.
I'll be honest with you, sir. I don't understand what that means.
I'm not guilty.
I understand that. Okay. All right. Anything else, sir?
No, sir.
Okay. Do you rest your case?
Yes.
Okay. Now, both parties have rested. At this point in time, the evidence is closed and all the evidence is assembled here for the court to review. At this point in time, it is appropriate for each party to make their closing argument. Mr. Winkler, would you like to make a closing argument?
Judge, for both cases, the officers testified that on April 9th, 2021, at the time specified in their testimony, that Mr. Crawford was in violation of the ordinance. The ordinance is ordinance section, Kennesaw Code of Ordinances, section 18-78. Judge, you've already recited the ordinance during the course of the trial here, so I know you're familiar with what the ordinance calls for. In the first case, the testimony was that it was in violation greater than 50 feet. The second case, in violation over 25 feet. Further, Judge, he testified that, I believe his testimony was that officers have been called out there 9 times to handle this problem. He's pled guilty 2 times before on this problem. He intentionally keeps doing it over and over and over again. It's taken up too much time and resources with the police department to handle something. This is not a barking dog case that he can't control or something, Judge. He's got the equipment right here that shows that he's putting the stuff outside and playing it in order to agitate people. He's forced officers to come out there 9 times. But they didn't write citations, and 4 that they did. It's ridiculous. They've tried to explain on multiple occasions the violations, and he refused to heed what they were saying. So on the first violation that we're handling today, the third offense, the fine would be pursuant to the ordinance section 883 requires a third offense within a 12-month period, fines $250 plus statutory surcharges. The surcharges are $87.50. The fine would be $337.50. The fourth offense requires a fine of $500 plus statutory surcharge be $175. That would, the second offense would be $675 fine total. Judge, on the third offense, the first case that we're dealing with today, I'd also ask for 6 months probation on that case. And the second offense, I'd ask for one consecutive to the first one. And I'd ask that 6 months probation, one consecutive on the second case to the first case as well. And I'd ask you to impose that sentence and inform the defendant that a violation of probation could result in him going to jail if he wants to continue to run his music outside in excess of what the ordinance allows. That's all I do.
Tell me what your closing argument is.
All right.
And this is a time where you can recap what the evidence says. Tell me how that proves your case. And then present what you think is appropriate to do.
First, in the name of Jesus, I'd ask for mercy regardless of what anybody has said towards me for this case, because I know that's always available. Second, what he said about the measurement and being, like he said, 9 times I was within the law, which means 9 times they came and said, yes, I know your neighbors hate you. Yes, I know they don't want to hear you or see you. They want you to go inside. Yet we know that you're within the law of doing this, so we will allow it. Over 9 times. That's just what that paper says. I do have others. I've got so much more, Your Honor, that just shows the abundance of, like you said, them wanting to do their job and me wanting to do mine, which is to be an American citizen who knows if they said I'm okay, I'm okay. And I try not to stop on really just being made fun of, basically being made fun of. I believe each of the officers that have come, I do believe they know. Again, if they weren't talking to me on an officer standpoint, we'd probably get pancakes and like freaking drinks or something like that. But yet that's not where we are. So no offense towards the ones who I have dealt with. I also know right now, my whole outfit that I have on, I can't even afford this outfit. So everything this man is asking for, I'm going to have to plead for mercy and that it cannot happen. And I have, since everyone has shown up and told me what they wanted from me, nobody else has had to come back because I've made the arrangements to make sure. Fine, I don't care. I don't even care about the fact that I'm legal. I just want you to stop having to come. So I've made those arrangements. And with those arrangements, we've had no problems. And that's extremely evident in everything that he's presented, that it's not about being a nuisance, because I am prepared to do what it's willing to take for you guys not to have to be annoyed with me. And I've tried to work hard to just be at the point where I'm even entertaining one person. And I don't want anybody to be able to take that away from me. And I just thank you for your time.
Okay. First, Mr. Crawford.
Yes.
You have done an excellent job of presenting your side of your case. You have presented your evidence, asked questions to witnesses, and presented your own witnesses. This is not an easy thing to do. For someone that hasn't done this before, you did an excellent job. I hear your side of the story and I understand. What we're here for is not a determination of is anyone a good person or a bad person or a benefit or a nuisance. What this case is about today is about whether or not an ordinance that was passed by the city council of elected officials, whether or not it was violated or not. It's not subjective. It's actually rather objective. It either was or it wasn't violated. Now, if it's determined that you did violate these ordinances, that does not make you a bad person. That does not make you having done anything that is morally reprehensible or otherwise even not enjoyable to many. I understand that your goal is to try to entertain, and that's what you've expressed very eloquently here this morning. However, that's not a defense. So what I have to look at is the evidence that's been presented and whether or not the city has carried its burden of proof of proving that beyond a reasonable doubt that ordinance was violated on these two instances. Given all the evidence that's been assembled, given all the witnesses that have assembled, given all the testimony that's been assembled, we look at all of it together. And I do find that in both counts, the city has carried its burden of proof and proved beyond a reasonable doubt that the ordinance, and that specific part of the ordinance with regards to 50 feet and 25 feet of audibility at certain hours was violated. So where does that get us? Well, what that gets us is that I do find that you are guilty of violating those two ordinances in that particular way. Now, technically, this is the third and fourth time that you've come before this court with these citations in the last 12 months. I know there's some more that are outstanding as well that haven't come to court yet. I'm going to treat both of these cases as if this was your third offense, although it is your third and your fourth for financial purposes. And each case, I find that you're guilty of violation of the ordinance, and I sentence you to a fine in each case of $337.50. In addition, in the first case, to 6 months probation, and that's to give you some time to be able to pay that overtime. And also, you may wish to request community service in lieu of that fine if you have a financial hardship. You can speak with your probation officer about that and that type of conversion, because I know you've testified about financial hardship already. In the second case, the sentence is the same, a fine of $337.50 and 6 months probation, which would be consecutive to the first case. So that gives you the opportunity to work to be able to pay those fines over a period of time instead of all at once today. So what you need to do today is you're going to need to meet with probation and talk about your case. There's some conditions of probation that I'm going to order, and they are that your probation in each case can be terminated after 1 month if the fines are paid in full, and that to pay fines and surcharges in each case at least in the first 4 months of that probation. Now, when you meet with your probation officer, if financial hardship is an issue, you can talk to them about conversion to community service and how you would go about being able to do that. Now, I don't want to discourage you from celebrating. You mentioned first thing when you came in here today that you celebrate every day and that it makes you sad that some people don't. It's fine to celebrate every day. In fact, I think it's wonderful and something that we all should do in our hearts every day, to be thankful to be here and thankful for the country we live in and thankful for the community we live in. But we have to sometimes temper how we celebrate to maybe not violate, in particular, these laws. Don't stop celebrating, but maybe let's do it in a different way that can be just as joyful and just as entertaining to many without ending up here. I don't want for you to continue to end up here. You have a cheerful demeanor, a very nice personality. You're very eloquent. And I believe, and it has been a pleasure to hear your testimony today. However, I don't want for you to keep having to come here and these officers to keep having to come out to your house. Does that make sense?
Yes.
may I add one last time, because they won't stop coming no matter what measurements I come. If I be put on probation, you already know these people are not liking me. They could call and then that's a wrap for me. I get set up to go down once again. I'm asking for it not to be done. I've taken every measurement, low, high, no morning, high, not at night, before everything I could do to compromise with the very people who, again, came as a mob first to our yard, a mob to ask about this. 3 adults come to do what? To fight for music? And now I'm here from these same people and I'm gonna put on probation? They gonna call the cops as soon as they can. They don't want me to spend, I'm gonna stay in jail for some music because somebody just don't like me?
Well, I can't give you legal advice, but what I would say is this: find a different way to celebrate. You can do that. If this has gotten you to this point of playing music on your front porch, don't play music on your front porch.
Your Honor, we went to school to be a judge in that chair. If I would have taken that attitude, you wouldn't be a judge right now. There's so many people that said, no, that's not the way to go. That's not the way to do it. Find something else. And you managed to say, I know this is the best way. This is the way to go. That's where I learned these stuff from, to stand up and make sure if it's a seat for me to have, I got to make it to that seat. But I hear what you're saying. Again, I'm gonna do what I'm doing now, which is, again, just keep it low where they're not coming anymore. But right now, Your Honor, to let you know, since I've been doing that, the same officer just showed up this past Sunday, when I had it almost completely off, but they just called because it was Sunday. And if that happens, I'm in violation. What can I do
Well, it sounds like
about
you
that?
didn't get it. If you didn't get a citation, you weren't.
Right. That's what I'm saying, though. You just saw 9 times I didn't, but you just found me guilty. It sounds like I'm going to be on that same path. I'm asking not to be on that path.
Well, I'd say the best way to not be on that path is just keep it quiet. Keep it quiet. You can still celebrate. You can still entertain. And, just know that everybody's watching.
They've been watching. That's why we're here. That's why
No,
I've asked them to help me.
The court in probation is watching at this point in time.
Right.
Okay. And what I'm watching for is to make sure that you're treated fairly and that everything moves forward as orderly as possible.
Your Honor, I'm coming back to see you for these same cases. If this is any indication of that, then I'm in violation of that probation right now.
No, sir. No, sir. I will tell you that right now, that because of the citations that are already written, that will not violate this probation. Okay?
Good. That'll definitely help for sure.
I understand. Okay. Now that's where we are right now. So now at this point in time, our goal is several fold. I need for you to speak with probation. They're going to call you back in a few minutes. Talk to them about your case. Okay?
Okay.
Okay. Second, we need to move forward, onwards, and upwards. Excelsior. Okay?
Yeah.
There we go.
Oh, I'm glad you said that. How can I move forward if I backslide? If you said there's another way to celebrate, the only one that I know is written in Psalms 49, which it says loudly. And if I don't do those things, then how can I have Excelsior?
I understand your argument. Unfortunately,
I got you. You're doing your job. You're doing a great job. Since I have this time to talk to you in a peaceful way, I'm just trying to do so. That's all.
I appreciate it. Unfortunately, the theological mysteries of the world is beyond me as well. But I wish you good luck, sir. So
Hey.
you'll have a seat in the courtroom.
Thank
We'll
you.
get you to probation in just a moment.
Cool. Thank you, sir.
All right, good morning, everyone that's here for the 11 o'clock calendar. My name is Judge Mays. This is the City of Kennesaw Municipal Court. I appreciate your patience. Go ahead and call through that calendar. The matter on the calendar for 11 a.m. is the matter of City of Kennesaw versus Christelle Pierre Luis. Good morning, ma'am. How are you? Have you had the chance to speak with the solicitor about your case? Okay, then. We'll let you have a few minutes to take care of that. Cheryl, would you ask Mr. Smith to step back behind it and change this real quick?
Hey, thank you. Hey, real quick, you said we don't have any answers for those type of things. So if you look at it, since nobody has an answer for the spiritual, now we don't even have an answer for the scientific. So who has answers? So how do we make rulings off of the whole world? We have no answer, but yet I'm found guilty.
Good question, sir.
Hey, so I'll just tell him. Again, you're working in a field that Jesus again said, you guys have a law book, then you have a Bible that says right next to it.
Yes.
And Jesus came and said, what about that law book? Like he said, even I can't even live Excelsior, right? I can't even live that. So what they're telling me is I can't live spiritually or Excelsior because
That's not what he's saying.
because in order to make it to the judge seat, right, I have to obey what Excelsior says, right? Which says, what does it say? Praise and worship loudly, and our mouths, again, thankfully, that's why I called you up to show the fact of it's not, again, loud, but if you don't have joy here,
Right.
you don't want to hear anything.
Exactly.
Right? Just even children, you'd be like, I don't want to hear your voice. Go in there and sit down. I said, you're not going outside. Yeah, you can't. Jesus got punched in the face and they said, again, do you like this ruling? And he didn't answer. He spat on him. They said, who hit you? And those all come from the governing of what? The book that's not here. And this one says it's okay to do that, which is why we have guilty pleas. So you just got to guard
But
this.
Jesus also loves the peacekeepers,
Yeah,
and he ordains
Yeah.
the peacekeepers to do
right. But if
the law.
the man of law hasn't been written from Jesus, or again, like the 10 Commandments, so if it's written by men, what does that mean? Then it's no good because men wrote it. If the Bible is written from the Spirit of the Lord, right?
But
Governing
if the
the
law is
apostles.
written from
whose law?
by direction
Whose
of the
law?
Bible,
Whose law? Where
The law-
did Jesus
law of the
direct the
land.
lawmakers? Tell me when. And what did Paul say about
I
the
can't get
lawmakers?
philosophy.
What did Paul? It's not philosophy. Again, this is commandments from Jesus. I don't talk in philosophy. I don't do this because of philosophy. It's written down. This is how you will govern your life. That's why you have the outfit. When we showed up in the neighborhood, you want to know what they called us? That's when they called us Christians for the first time. So they were mocking us when we showed up at Antioch. So we showed up in our police outfit and they said, oh, look at those Christians. So it wasn't a name of, man, you guys are awesome people. I'm so glad you're here. No,
Not
it was a
back then,
name.
no.
It was a name. Even now, it's still a mocking name now. Why? Jesus himself said, I didn't even come in my own name. I came in my Father's name.
Right.
Yet even in 2021, people come in whose name? Jesus' name. But he said, I came on my Father's accord. And the ones that show up later and say, I showed up in your name, Jesus, I casted out demons in your name. What did he say? I'm going to tell them I never knew them. He said, I didn't come according to my name, which that's where they got Christian from, right? Christ-like.
Right.
He said, I didn't come for that. So anyone claiming those things, what did he say? If they don't believe in me, who's here for my Father's will, what did he say? They are the Antichrist. Not he's coming. No, he said anyone, they are. Right? So you gotta
Hang on a second.
details.
Yeah.
You gotta be careful.
We'll talk about this later. So you gotta fill this out first, and then progression back in and we'll litigate, okay?
Dude, this is crazy.
Yes, they are. And don't forget your sunglasses, man.
I'm up in here trying for some music that's written in scripture, yet they want to. I know it makes sense. Again, why would you again stop what God wrote down, but you're gonna obey a book that very common man wrote down? It don't make no sense, right? Oh, it's a for sure no to Jesus, but we gotta think about it when it comes to the court of law. That makes sense.
We'll continue this conversation later, all right, bud?
There's always later until there's no later.
Very good.
Yeah.
Great.
Yeah. Little lady, I tried to hold it together in front of you. I was trying, girl. I was like, I'm just getting sanitation, just getting sanitation. It wasn't working. It wasn't working. So excuse me, but it happens sometimes. It does happen. But you held your own though. You just hold it down, girl. I was trying to draw confidence from you. She's like, she's staying strong, stay strong. It was working. It was working. I'll see you on the next go.
All right, take care. I'm well, how are you? It's okay, thank you. That's correct. Yes. Yes. Yes, that's correct. Yes, I do. Yes. Yes, I have. Yes. Yes. Yes, I have. Yes. Yes.
The solicitors made a recommendation in your case of fine $227, 12 months probation getting terminated. Fine. And pay for the next 30 days. Probation fee would also be waived. Is this what you'd like for me to accept?
Yes, please.
Are you a citizen of the United States?
Yes, I am.
Forcing you to enter this plea today.
No.
Are the allegations of the city with regards to this charge essentially true and correct?
Say it one more time, I'm sorry.
Are the allegations of the city with regards to the charge of speeding 15 to 18 over essentially true and correct?
Yes.
All right, I'll accept your plea of no contest to speeding. I find that the plea is freely and voluntarily given and that there is a factual basis for your plea. The sentence of the court is a fine of $227, 12 months probation with the terms and conditions of probation that we just discussed. You will need to meet with probation briefly before you leave today. So if you'll have a seat in the courtroom, they'll call you back in just a moment, and I wish you good luck.
Thank you.
Yes, ma'am. All right. Then you can be excused. You're welcome. Do you have anything with us this afternoon? All right, thank you so much. We'll stand in recess until 2 p.m., I believe. It's our next calendar. Isn't it, is it 2? I believe it's 2. 2. Then we'll just hold for his report on that one. Well, I've got two on the 2 o'clock.
Oh, Cardenas.
Cardenas.
Cardenas was a missing ticket, so I don't think we're doing anything with that.
Is that going to be dismissed? Is that what's going to happen?
That's what I'm thinking.
Oh, it's a DUI. What happened with it? Did you have a nice lunch?
I did. Very nice.
Good.
You?
Good afternoon, Judge. Well, having technology issues.
Oh, no, I'm sorry.
Yeah. Well, I had a calendar call via Zoom at 2 o'clock. But I appreciate that. I sent him a text saying I had technology issues, and then I'll contact him after we get this done. Judge Morrison, State Court of Cherokee County. Well, it was a jury trial calendar call. No, and in fact, we came up with agreement yesterday and we waived the jury trial. So, I think he just wanted to, because it's on Zoom, we submitted the documents. He wanted to confirm with my client that.
Well, I've got a mobile device that I can use anymore.
Well, I'll try. Can you get Gmail there? You got?
Yeah.
You get Gmail on?
Copy of this.
Did that work for you, Mr. Brown? It did, thank you. You are welcome. I'm glad that worked. Don't run off with my, tablet. No, I'm good with that. I'm just kidding.
I saw these yesterday. Sometimes the intrudes, Are you okay with this start? I'm fine. I'm good. Did you have a nice lunch? Had lunch. Food just was a lunch. When did you do the cheeseburger, Roberts? Yes. Good. I had chicken. You had chicken? Good. You had chicken, Bob. Good. Especially Star Trek. Yeah. But yeah, that technology. Yes. Kind of exists now. Some exploration. Yeah, Miss Sylvia. What do you hear? I'm sorry? What do you want? Just try that. We're so glad you're here, though. Okay, thank you. Hello. Hello. What's going on? Not much. We have one to do. I knew something was here because.
Oh, no, absolutely. Totally understand.
So my understanding is that a solicitor has-
Thank you.
How long did you talk about time?
Yes, that works perfectly.
Okay, fantastic.
Mr. Brown, Lisa will have.
Oh, okay.
Yeah. Super. And you were able to get to your hearing?
I may be now.
Fantastic.
I appreciate it.
Well, of course, it's my pleasure. My pleasure. You're welcome. Always good to see you.
So it will be in November. Okay, gotcha.
Okay, back in the day. What were?
Yes. Just continue to reset the we weren't going to go up. All right. We appreciate you. Good, you doing okay? Mr. Moore, this is Jeff Mason. So how are you doing today? I'm good. We have your clients on the dock. I found that they for information verification here. And we're wondering if we can expect. Yes, yes. Actually, let me give you Mr. Smith's phone number. So you can call him. 770. And then be sure to post that in many places that you can. Okay, that sounds great. We appreciate you. Thank you. Did y'all notice August report for Mr. Nixon is actually positive? Yes. It's only been 8 months worth of treatment, and you finally made it from uncooperative to. I mean, that's better. Hey, what's your favorite? I'm good.
You did what?
I make the same stuff on the inside.
Well, you see, the earth revolves around the sun. And it spins as it goes and makes one revolution like this, the earth does a day. And so when we started today, we were at the earlier part of of that resolution, which or the revolution, which in this part of the world we call morning. And see now we're but you're missing the scientific answer to your question. Oh Lord. I love trial days. So then.
And after that happens.
Uh-huh. This is what happens when I don't get to talk to 1,500 people every day and ask them, is this their signature?
You definitely use your allotted words for the day on court days.
Over and over and over again, the same ones. Oh my goodness gracious. No, it's funny. I think I have dreams at night going through the plea litany just because it's just so automatic. But then, you know, I was thinking about it and it's like, okay, yeah, if we're doing that 3 times a week for approximately 50 to 60 times a day. Yeah. No wonder when I go home, I don't want to talk to nobody.
I hate to talk on the phone when I get home.
Yeah, me too. I'd just be home because usually I get inundated from all angles when I walk in the door, which is sweet and kind and nice, and everybody's happy, you know, and I think that's wonderful. But right then and there, I just want everybody to
Right.
give me 15 minutes. Let me try.
That's the one good thing about living farther away from the city.
Is the drive home is relaxing. Yeah.
Yeah.
Peaceful. Yeah, hard to say that in Cobb County traffic. It is just amazing how it's, I mean, school starting this year made the most significant change that I've seen it make in a while.
This morning was crazy.
Oh, yes, it was.
My friend left at 4:30 to drive back to Pittsburgh. So I got up at 4:30 and went back to sleep. And then I guess I told the alarm to shut up.
Oopsie.
Driving 12 hours. I couldn't drive 12 hours straight.
You know, I could when I was younger,
She's
but I don't think I
70
could anymore.
She's 73.
Oh, my goodness, bless her heart. That's
Yeah.
that's a lot of stops at Starbucks is what that is.
You'd never
I
know.
mean, I don't like
but still.
Starbucks, but on the road, it's the best thing because it will absolutely pry your eyes open and
She had a big
you
thermos
awake.
of coffee, then she made one to take with her.
yeah.
And I thought,
And then you got to stop every 10 minutes to pee. That happens.
well, I talked to her when we went to lunch. And she was in West Virginia.
Oh, well, she's making good time.
And she said she had stopped 4 times. I was like,
Oh, I showed help, but I didn't show you, Linda. We got the first of Eli's senior pictures back. He had a whole thing done and they sent us one as a teaser, you know, the way we just got it back. It turned out pretty good.
They are
If
good.
they're all that good, we're in business.
Can we, do we, oh, there's only one?
Yeah, there's only one so far. We should get the rest of the proofs this week.
That's good. Exciting. See,
It's all grown up.
about
We need an
time.
officer to separate this. It's very contentious. back
Is
there.
it that contentious? Fantastic. Well, let's see here.
Judge, I think we've reached compromise here.
Oh, okay.
Resolve the motion for today.
Oh, that's a shame. I was really looking forward to all of the learned arguments we were about to hear.
This is my pet peeve. I was psyched. But I think we might,
I'm glad y'all able to, the court, as it always is said in such a dry tone, the court favors compromise. So yes, so we'll take it.
So Judge, either we're gonna figure out a resolution to the case.
Sure.
Or I'll redraft the active section, to make it more specific. That's fine. Put it out.
Okay, so technically, are we continuing the motions or are we withdrawing?
Without prejudice, I'm withdrawing it.
Yeah, there would be no prejudice to it because the court's not ruling on it. It isn't something that's actually occurred, so that would be fine. We'll just call them withdrawn at this point in time. You're welcome.
Nice.
That sounds like fun.
All right.
Always good to see you. We'll just send it. Yeah.
How much time do you need, sir? Okay.
Good work. Thank you. No, thank you, Jamie.
Thank you.
Yeah, we've got one probation case to hear, and I think that's it for us. So we're all good. Thank you, Jamie. City of Kennesaw versus Mr. Starnes. How do you plead?
I didn't do it. I was just recording the video.
And dancing in my backyard.
Nope, I wasn't dancing. I was prancing.
Oh, my goodness. Let's see. So we're down to one attorney we're waiting on and Mr. Turcotte in the jail.
So attorney just called. We're willing to go. If it's okay with them, we're willing to go forward. Just to consent order with the place in the day. Confirm him that he still has a place in. Mental health court said yes. He just needs to report to so-and-so tomorrow. So-and-so's name, but I'll come back and get it. I told him I'd call him either way, let him know, but. He says, well, I told him I represent him, if he needed help. But if consent order on the table, let him out today. Yeah.
Okay, so we need to probably get the jail on the horn, see if we can get them on the Skype. And see what we can do.
While you do that, can I call him back and get that lady's name?
Absolutely.
So we can get it on record that we talked to him.
Sure can. And the beat goes on. No, why not? Hey, this is Judge Mays. How are you? Oh, we're just peachy. I was calling to see, could you see if Mr. Turcotte will grace us up and book in and get on the Skype so we can have a revocation hearing with him?
Yes, sir. We are.
You are awesome. Well, I'll call in, I guess, in about, what, it should give us about 5 minutes. Will that give you enough time? Oh, you're awesome. Thank you so much. I appreciate it. Bye-bye.
She probably won't be back. Depends on when she moves. Isn't it Monroe where she's from? All righty.
You want Judge Basis?